Start. Welcome to the Commerce and Labor Committee. Just a couple of announcements before we start. I'm going to read the numbers of the energy bills. They're being sent to Senator Spruill's subcommittee. And, excuse me. Yes, the roll call.
Voted on nothing yet.
Mr. Chair, you have a quorum.
Thank you. These bills in subcommittee will be heard Wednesday in room 2, subcommittee room 2. That's on the 5th floor of this building, okay? And I would encourage all of the interested parties to try to meet in the interval and see if you all can't come to a consensus. I'm not expecting unanimity, but if you can get, a fair amount of people in support of of one bill, if we can include everything in one, or if some, can't be done, we'll do it another way. But see if you all can't reach an agreement. I've talked to one of the environmental groups. I've talked to Dominion Resources, and they're going to get together. So you all know who the people are. See if you can't work something out. Okay, we're going to do something, and like I said, I don't expect it to be unanimous, but let's try to get as much of an agreement as we can, or consensus. These bills are Senate Bills 984, 1075, 1265, 1321, 1417, 1419, and 1420. Okay, so if you have those bills, start making arrangements. All right. Two bills that we're going to re-refer right off the bat to Ed and Health. They should have gone there to begin with. Senate Bill 1327, that's Senator McClellan's, and Senate Bill 1416, Senator Pillion's. Have a motion. Second. All right, it's been moved and seconded. All those in favor of re-referring, I think voice vote. Oh, okay.
Ayes 15, no zero.
Okay. All right. We will start with Senate Bill 828. That's Senator Spruill.
Good afternoon, Mr. Chairman, the committee.
Good afternoon.
828, Mr. Chairman, long-term care insurance premium rates increase. It prohibits the State Cooperation Commission from approving any long-term care insurance and premium rates, increased premium rates, schedule increase, not to exceed 6% of the current schedule. And Mr. Chairman, it came out about because we had constituents from me, and yet my friend Martin Mason called me as well. We're concerned about the rates, sometime yearly, of these companies increasing their rates on their constituents. It come about, let's say, for example, you would pay into the plan for 25 years while you're young. And now when you get old, you go into the plan. Next thing you know, it's increased. I had some of the insurance to come by the office to talk to me about it. And I said, but what happened, for example, if the plan that you approved, I've been paying for 30 years, I go into the plan, it's $1,200, and all of a sudden it has to increase. Then the next question they explained to me is that some of those tiers are 7 tills. And let's say they take one till, in my own language, let's say one of the tills is the I that I'm covering. It's just for an example. And they said they could raise that for $40. I said, is it per month? Yes. So that $40 would be added on to the $1,200. But all these many years, I've been paying the premium for that. And then they explained to me is that you will get the coverage on what you paid for. But what I started paying for 25 years ago and what I needed right now, the coverage is much greater than what I did 25 years ago. Then I was explained by some of my colleagues is that if this 6% approved now, that it pretty much will shut the company down. And that I don't want to do. So I asked all my colleagues, including my friend Senator Lucas, bless your heart. I say, will this hurt? Will this have any problems? And they said yes. So I'm saying, well, maybe I'm putting it in because we need help from our constituents. How can we help our constituents, those who are paying all these many years, and now they need it, and now all of a sudden now they cannot afford to stay into the plan. So what can I do? So I'm open to suggestions, Mr. Chairman, and I will ask you that any suggestion that you have, we don't have no long discussion, I don't need a long line, I don't need that. Someone just help me out, please. Adam, please.
Mr. Chairman? Senator Evan? I'm wondering, I don't want to shut anyone down, but I'm wondering if this might be a topic for the Bureau of Insurance to study in the interim and report back to us before we take any action that would adversely affect the plans. Probably not a bad idea. All right.
Second the motion.
Form of a motion?
Second.
All right.
That's a good idea, Senator Spruce. I won't use that in the campaign against you in June.
Okay. All right. All those in favor of,
Oh, bless your heart, Senator.
all right. Yeah, the motion would be to pass by indefinitely with a letter to the Bureau. All those in favor of passing it by indefinitely, but with the chair sending a letter to the Insurance Commission asking that they study this topic and report back to us before the 2024 session. All those in favor, register your vote. Aye. Those opposed, nay. I'm not Senator Norman. That's
Ayes 15, no zero.
Thank you.
You're welcome, Senator Spruce.
Thank you, madam. I appreciate that.
all right. The next is Senate Bill 840 and a request by the sponsor that it go by for the day.
Mr. Chairman, only thing I would say is this bill is actually identical to SB 1039, Senator McPike's bill.
Right.
And if it's, Senator McPike said he was okay with rolling his into mine, so if the committee wants to do that and then pass it by, that would clear the docket a little bit.
All right. All those in favor of rolling Senate Bill 840, no, you mean 1039 into 840? I don't think that has to be, is that recorded? Yeah. All right, vote aye. And it's bye for the day.
Ayes 15, no zero.
All right. 904 is Senator DeStaff's workman's comp billing, post-traumatic stress disorder, anxiety disorder, or depressive disorder, law enforcement officers, and public safety, telecommunications firefighters.
Mr. Chairman, members of the committee, thank you for having us today. I'd like to first start that we have a substitute, I believe.
Is there a motion to adopt the substitute? All right, it's been moved and adopted that we, moved and seconded that we adopt the substitute. All those in favor, vote aye.
Aye.
Aye is good. All right.
And Mr. Chairman, if I can, so Senate Bill 904, background a little bit is the average person experiences 2 to 3 traumatic critical incidents in their lifetime. A law enforcement officer, similar to our military, can experience as many as 180. And, Mr. Chairman, police officers and firefighters are at a higher risk of suicide than any other profession. Both police officers and firefighters, more of them die from suicide than killed in the line of duty. That's important to remember. More of them die by suicide than are killed in the line of duty. Suicides outnumber the line of duty deaths almost every single year. So the substitute that you're seeing today is a little bit different than the original bill, and I'd like to explain it. It does three things. The first, it addresses anxiety and depressive disorders. Second, it has law enforcement that during their training academies, that they're trained on how to recognize depressive and anxiety disorders. And really when somebody's stressed or somebody's at that point where you think they're about ready to give up, how to recognize that, how to intervene and intercede. And then third, it changes the date of the qualified event. So those three things are how we focus on this bill. It's a little different than Senator Ebbins' bill, which talks about dispatchers. We're not going to get into that here. This does not include dispatchers or correctional officers. This is specifically focused only on police officers and firefighters. And we have a subject matter expert here, Maggie DeBoard, who would like to, at the appropriate time, who would like to chime in and fill you in on a little bit more of the details. But this bill is pretty direct and pretty simple, and we've tried to narrow it down closely. Thank you, Mr. Chairman. Happy to answer any questions as well.
Any questions of Senator's staff? Okay, welcome.
All right, Maggie.
Good afternoon, Mr. Chairman. Thank you for allowing me to speak briefly with you about this topic. I'm here just to tell you how badly we need your help. The PTA.
Your name again?
I am Chief Maggie DeBoard from the Herndon Police Department. I'm also here representing the Virginia Association of Chiefs of Police. We need your help. The PTSD bill, when it was passed back in 2020, was a huge step toward getting our first responders, both police and fire, some help and some treatment when they struggle with what is very specific in the code about a qualifying event, those difficult challenges that we have. But the PTSD bill really is not helpful in the sense that an officer will have to be fully diagnosed with PTSD before they get any type of clinical treatment for the problems that they're experiencing. And what we typically see is before somebody gets to that point of PTSD or suicide, they get things like they get depression, they get anxiety from working a multiple child death or a bad use of force situation or a mass casualty event in the community. So what we are trying to do is be preventative with workers' comp instead of waiting until somebody becomes almost disabled to get the help. We also know that it's really important that if we want to build trust with our communities, we have to have really healthy first responders. That's really, really important. And we did the very first, the most comprehensive survey back in 2021 in the state of Virginia. And those survey results showed that among law enforcement in Virginia, 19% had moderate to severe levels of depression. 20% had moderate to severe levels in anxiety. 12% had significant levels for PTSD, and 12% had suicide ideation within the past month. And those stats are very, very concerning. They're far above the national average, and we need help. And I'll just kind of make this analogy, and I'll close with this. When we watched the football game a couple weeks ago and you saw a player go down, and all I saw in the news over and over again was how difficult it was for those teammates to go back out and play a game. Well, we don't get to postpone. We don't even get to go home some days based on the smaller jurisdictions that work in this region. And the people that say, well, you're used to it, we're not used to it. That trauma accumulates and it becomes very, very debilitating. And all we want is to get some help. That's all we want is to get some help so that we can stay in the game and serve our community respectfully. Thank you.
Thank you.
Mr. Chairman,
Next. Oh, Senator Surville.
I have a question for council. Could I ask that now, or you want to take the testimony first?
Well, let's go ahead and hear.
All right.
Welcome.
Thank you, Mr. Chairman, committee members. Jennifer Pike, on behalf of the Virginia Professional Firefighters. Our firefighters, paramedics, and law enforcement officers bravely protect their communities every day. They're willing to sacrifice themselves to save others. Over the course of their career, they experience exposure to horrific events, which often lead them to becoming ill or suffer from mental health issues. We know that their roles and responsibilities position public safety personnel in situations that increase levels of trauma. The men and women who serve our communities in the Commonwealth deserve the benefits outlined in this legislation before you today. Senate Bill 904 adds anxiety and depressive orders to existing legislation and provides our firefighters, paramedics, and law enforcement officers early access to behavioral health treatment. Mr. Chairman, committee members, I hope it's the will of this committee to pass this very important legislation today, which will make a huge impact on the future of all of our men and women in uniform. Thank you.
Thank you.
Those on Zoom that would like to provide testimony, please wait until after in-person testimony is finished. Thank you.
Mr. Chairman, members of the board, members of the committee, my name is John Wright, firefighter for 25 years, Frederick County, Virginia. As Maggie attested to, the depression numbers, the anxiety numbers, the rates of suicide have dramatically increased, certainly over the last few years. A five-fold increase over their civilian counterparts from the constant exposures. Last session, the Virginia Senate passed this legislation 40-0 and sent it to the House, where it got tripped up. So we hope that it will be the will of this body to pass it once again. Thank you.
Mr. Chairman, members of the committee, Jeff Smith. I'm here on behalf of Virginia Self-Insurers Association, as well as Metis Holdings, Inc., the company that oversees all workers' comp and liability claims as part of VACO's risk pool. We thank the patron for working with us, as well as the interested parties, to find a resolve in this area. It's a very important issue. Thank you.
Okay, thank you. Welcome.
Good afternoon, Mr. Chair, members of the committee. Jeremy Bennett with the Virginia Association of Counties, VACO. Just echo Mr. Smith's concerns that we're never opposed to the intent of this bill, but we really appreciate the patron addressing the majority of our fiscal concerns and working with us on that. So thank you.
Welcome, Senator.
Mr. Chairman, members of the committee, here on behalf of the Virginia State Police Association, we're in support of the bill.
Thank you. All right, Senator Marston.
Thank you, Mr. Chairman. On top of that, one of the very much overlooked things with regards to our emergency services workers and police, fire, is all of the things that has been stated are true, and they're very difficult to deal with these traumatic experiences. And you layer on top of that the fact that you're working shift work, that you're not there with your families at times when you need to be, that you're awake when everybody else is asleep, the things that you miss, the stress that adds to already traumatic circumstances is often overlooked in these discussions, but that's what these folks go through. And at the appropriate time, I have a motion.
Okay, Senator Serville.
Thank you, Mr. Chairman. I got a question for Tom. My recollection is the original statute, the one that added or that we passed to say post-traumatic stress disorder was compensable, was because there was a Court of Appeals opinion which held that that PTSD was just simply ineligible because it was kind of expected part of the job or something like that. And that's why we had to pass the original statute. Is that right?
Mr. Chairman, Senator Serval, I believe Senator is correct.
Okay. Further questions, Mr. Chairman? Thank you. So I understand we're at. Are you aware of any authority, legal authority, that says that anxiety and depression sort of fall within that same prohibition? Or I'm just trying to understand sort of how adding this to that would fit into the existing legal framework. I'm not a workers' comp lawyer, and I know you have to show proximate causation in the absence of a statute. I guess you'd have to show that the anxiety or depression was proximately caused by whatever was witnessed, which is, for some reason, in the workers' comp world, the court in that case had held you're not allowed to do that with PTSD, even if because it's expected or something like that. I mean, are we trying to reverse another case here, or are we trying to create a whole new regime with this, or what?
Mr. Chairman, Senator Serval, I'm not aware that Senator DeStuff is trying to reverse another case.
Okay.
Senator Norman.
Thank you, Mr. Chairman. A lot of extraordinarily good points have been made, but also if we put it in the context of the atmospheric conditions that we've been through with our law enforcement and public safety officials, to me, this is a very modest expression of respect and appreciation, and I'd move we report the bill.
Second.
Second.
Yes, to finance. Right. Yeah. The motion is to report and re-refer to finance. All those in favor, vote aye. Opposed, nay.
Mr. Chair, members of the
15, no
committee, thank you very much. Have a great day.
Next is, well, I have my own bill here, and it's a brief one. What it does is it adds a cancer presumption to the workman's comp for firemen. They are 9% more likely to contract cancer than the general population and have a 14% increase risk of dying from the disease. In 2022, of the 469 names added to the Fallen Fires Memorial in Colorado, 75% died from occupational cancer. And the original cancer presumption statute we enacted in 1994, this just essentially adds to it. July of 22, the Agency for Research on Cancer reclassified the occupation of firefighting as a Group 1 carcinogen. And this new classification now puts firefighters on par with tobacco and benzene. That's essentially the bill. Is there anyone testify in favor?
For those on Zoom who would like to provide testimony for this bill, please raise your hand electronically and you will be called on after in-person testimony. Thank you.
Ms. Pike, could you come forward and speak?
Yes, ma'am. Thank you. Mr. Chairman, committee members, Jennifer Pike, on behalf of the nearly 10,000 members of Virginia Professional Firefighters, Senate Bill 906 is important legislation which will add cancers which are not currently covered to the existing list of presumptive cancers covered under Virginia law. You and I wake up each morning and we choose what clothing we put on and go to work. The men and women of professional fire service do not have that choice. In order to do their job of protecting and serving each of us daily, they have to put on protective gear, gear which has been found to contain carcinogens, which are subjected to high temperature. It causes occupational cancer. Yet these men and women are still willing to sacrifice themselves to save others. Over the course of their career, they're exposed to unseen cancer-causing toxins while performing critical public safety responsibilities, working within the communities we live. When they become ill from occupational cancer, they and their families should not have to worry about their health care coverage. We appreciate the stakeholders with this bill as we've worked diligently with them since early summer, and we hope that we've come to an agreement on an amended bill, which I hope you have, Senator, with you.
Senator Sasslaw?
I have not seen, all I got is the original bill. There's an amendment to it that you've worked out. I have not seen that.
Okay,
So,
there is an amendment to the bill.
Tom, do you have the amendment? Yes. Yeah.
Very simple, removing non. Non-Hodgkin's lymphoma and melanoma from the bill. We're striking those two.
Okay.
We're keeping bladder and thyroid cancer.
Okay.
Thank you.
Okay. Thank you all.
There's a motion and a second to the amendment? All in favor, voice vote, please say aye. Aye. Nays have the same right. Thank you. Next speaker, please.
Good afternoon, Senator Saslaw, members of the Labor and Commerce Committees. I'm honored to be before you today. I want to take a little bit different stance on the funding. We do appreciate, we hope you support this, but I don't want you to feel like firefighters are just sitting on their laurels, not doing anything. In the Richmond Fire Department, my name is Keith Andes. I'm president of the Richmond Professional Firefighters Association. I served in the Richmond Fire Department for 35 and a half years. At no time has cancer been at a high risk as it is now. We have tried and worked on some, putting policies in place where we have capturing systems to capture the exhaust diesel out of our stations. FEMA was, we were able to gain a grant through them that paid 80% of the cost. Richmond is sharing the cost at 20%. We have a no tobacco use policy in our department. We have comprehensive physicals that we do each and every year. So we're just not sitting, waiting for cancer to hit us. We are taking proactive approaches through policies, working with our administration to do so. So I ask you to support Senate Bill 906. Thank you for all you do, and thank my brothers and sisters for the work they continue to do for our communities.
Thank you for your testimony. Next speaker.
Hello, Madam Chair, members of the committee. Devin Cabot on behalf of the Virginia Fire Chiefs Association, and they strongly support the bill. Thanks.
Thank you.
Mr. Chairman, John Wright again on behalf of Frederick County Professional Firefighters. So as the previous speakers have mentioned, firefighters continue to receive the dreaded news of cancer, whether it's themselves or their fellow brother or sister firefighter. And last July, as you mentioned, the World Health Organization's top research of cancer reclassified firefighting in and of itself as a carcinogen over the course of the career from toxic exposures. Last year, 50 firefighters diagnosed with occupational cancers, 18 of them not even eligible to file a claim for coverage or for consideration because their cancers are not covered by the current code. We'd ask you to report this bill and act favorably upon it. Thank you.
Thank you. Next speaker.
Madam Chair, Jeff Smith, Virginia Self-Insurers Association, and Metis Holdings again. As Mrs. Pike stated, they reached out to us several months ago, and we were able to take that time to find a consensus. So thank you.
Thank you.
Madam Chair, Jeremy Bennett with the Virginia Association of Counties. Just want to thank the patron and the stakeholders for coming together to an agreement that addresses the majority of our fiscal concerns in the bill.
Thank you so much. Are there speakers in the waiting room?
There are no electronic speakers, Mr.
Thank you.
Chairman.
Senator Saslaw, we're going to turn this back to you for wrap up.
Okay, there's no other questions. It's time to vote.
Could I get a motion?
Move to report as amended.
The motion is to report and re-refer to Senate Finance as amended. All in favor of that motion, please designate electronically.
Ayes 15, no zero.
Ayes 15, no zero. The bill is reported and re-referred to Senate Finance with amendments. Senator Saslaw.
The next bill is Senate Bill 927, Senator Favola.
Mr. Chairman, I ask that go by for the day. I ask that go by for the day.
Go by for the day.
Yes.
All right. Without objection, Senate Bill 927 goes by for the day.
I do have Senate Bill 1000 if you're ready to take that.
Okay.
And it's very quick. Basically, what this bill does is it allows a health agent who is selling insurance and a property and casualty insurance agent to now sell paid family leave insurance. That's all this bill does. As you know, last year we passed a paid family leave bill, which essentially allowed the Bureau of Insurance to qualify certain insurance companies to offer paid family leave to employers. What this bill does is it expands the number of agents who are able to actually sell that insurance. I'm carrying this on behalf of the Bureau of Insurance.
Okay.
That's it. That's my bill.
Of the paper? All right. Anyone in favor of the bill? Anyone opposed? Anyone care?
Second.
I care.
I know you do. I know you do. I know you do. And I think we all do. All right, there's a motion to report. Is there a second?
Second.
Motion and a second report. All those in favor of reporting Senate Bill 1000, vote aye. Those opposed, nay.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you.
Ayes 15, no zero.
All right, 15-0, the bill is reported. All right. Next is Senate Bill 957. That's Senator Peterson's Prescription Drug Affordability Board and fund establishing that and drug cost affordability review. And I understand there's a fair amount of controversy on this, so Senator Peterson's not here.
He's in higher ed.
Well, we'll let it go by temporarily. All right, so by temporarily. Okay, Senator Peake, you're up with 974, Financial Institutions, Consumer Finance Companies, Authority of the AG to issue civil investigative demands.
Thank you, Mr. Chairman. It's a simple bill, and we've got people here to speak on this. It's to give the Attorney General the ability to issue CIDs. They are request civil investigative demands, CIDs, before actually filing suit, so they can research it a little better and get better information. Saves time. You look
Give
like
us an
you're.
example of
CID.
Who we got? Come on up here, David. Give the chairman an example.
Sure, Mr. Chairman, members of the committee, just if we're investigating, the consumer finance statutes apply to anyone who is making a consumer loan and charging more than 12% who isn't licensed, regulated under some other scheme. So if we're investigating someone who is doing that, we would use this statute. A couple of years ago, we had a company out of Tidewater that was making foreclosure rescue loans. And they were doing it in a kind of an unusual way by imposing charges through either a below-market option to purchase or an above-market real estate commission. So we investigated under this statute. A couple years before, it was a cash advance company that operated brick and mortar all over the state, Allied Cash Advance. They were not using the open-end credit laws as it would have allowed them an exemption, but because they were imposing an immediate finance charge, we investigated under this statute. So those are the two most recent examples. Years and years ago, before payday lenders, motor vehicle title lenders, tax refund lenders were legalized in some ways, we investigated and brought actions against those companies.
Okay.
And we do need to move some line amendments, Mr. Chairman. Two technical line amendments. Do you have those?
Mr. Chairman, Senator Peake, on line 43, after G, strike notwithstanding the provisions of 59.1-199 whenever, and insert whenever capitalized. On line 44, after person, insert not licensed under this chapter.
Thank you.
All right.
And Mr. Chairman, to follow up, the Attorney General has the same.
Don't we have to vote on the amendments?
Hold on. Could you read that amendment one more time?
Yes, sir. On line 43, we're striking the first clause, notwithstanding the provisions of 59.1-199, and then making the whenever capitalized, because the sentence would start there. And then on line 44, after person, insert not licensed under this chapter. So the sentence would read, whenever the Attorney General has reasonable cause to believe that any person not licensed under this chapter has engaged in, is engaging in, or is about to engage in, et cetera.
Okay. All right, is there a motion to adopt the amendments? All right, so moved and seconded. All those in favor of adopting the amendment, say aye.
Aye.
Opposed? All right.
And then, Mr. Chairman, I'd just point out, the Attorney General has the same authority under the Virginia Consumer Protection Act, the Virginia Antitrust Act, and solicitation of contribution laws, and the Virginia Telephone Privacy Protection Act. So it'd put them on the same par for these financial issues.
All right, Senator Marston.
Thank you, Mr. Chairman. Is that usual language to deal with something where somebody is about to do something that you investigated as opposed to they have done something? Is that contained in these other referenced groups?
In those other groups that it says, gives them, this is the same authority they already have in those other types of
And
situations.
they use that about to language?
But is that the, Dave, again, I don't know the good language.
Short answer is yes. It appears in every one of them.
Thank you.
Okay. Any other questions? All right. Anyone here speak in favor of the bill?
For
All
those
right.
on Zoom who would like to provide testimony, please
Wait,
raise your hand
anyone to speak in
electronically.
opposition? All right. You have any online?
There are no speakers, Mr. Chairman.
And no speakers. All right. All right. You've heard the bill. You've heard the amendment. All right. There's a motion by
Second.
Senator Newman to report as amended. Is there a second? A motion and a second. All those in favor, vote aye. All those opposed, nay.
Ayes 15, no 0.
Ayes 15, nays 0. Bill is reported. All right. Senator Peake, you've got 986.
Yes, sir.
That's filing meeting requirements for corporations.
Yes,
Go
sir. Thank you,
ahead.
Mr. Chairman. These are amendments to the Virginia Stock Corporation Act. These are technical amendments recommended by the Virginia Bar Association's Business Law Section. They hope will help strengthen corporate charters and better align our code with generally used corporate law practices and modernize certain procedures connected with shareholder meetings. And they're very technical. On line 76, 77, we strike a few 8 words on 76 and 67. Then on line 126 and 127, we changed the deadline from 2 days to 5 days. And then it eliminates section C, which is duplicative of other parts of the statute already. So and that part of the language is strikes requiring a hard copy of the shareholder list at an in-person meeting or an electronic copy for a virtual meeting. With these changes, the list will still be available at corporate headquarters, at the site of the meeting, or electronically, which is the primary method used these days. No amendment on these.
Mr.
Okay.
Chairman?
Any questions of the patron? Senator Evan.
Yeah, thank you, Mr. Chairman. I wanted to ask Senator Peake, Section C, which is being eliminated, you said is duplicative. How would someone who's a shareholder get a list of the other shareholders entitled to vote after we eliminate that section?
And who is here?
Lines 139 to
Yeah,
144.
That's what I asked them. It says it's duplicative regarding language accessible share list still ensures, and I'll have to, where that is contained prior, do I have my, I do not see them here. Which lines it's duplicative of. Let's see.
Maybe it's the part right above?
It's right above, let's see.
I don't know why it's there twice.
Yeah, B covers it. The shareholders list for notice shall be available for inspection. And then you go into I, principal office, little I, accessible electronic network, and then and it's given 5 days instead of 2. So they go from 2 days, now they give them 5, and then that gives them more time to get it. And that's why you don't need it with C.
Are there any other questions of Senator Peake? All right. Anyone out there in support of the bill desiring to speak? Opposition? All right, the bill's before us. There's a motion and a second to report Senate Bill 986. All those in favor vote aye. Those opposed, nay. All right.
Thank you, Mr. Chairman, members of the committee.
Okay.
Ayes 14, no zero, one abstention.
All right. Next is Senate Bill 1011. That's Senator Edwards dealing with tobacco surcharge. I understand it's got some problems.
Mr. Chairman, members of the committee, this bill was passed last year by both houses and vetoed. And we have an amendment that the governor has proposed, which is fine with everybody, I think. What this bill does is a recommendation of the Joint Commission on Healthcare, I believe. What it says the idea, the insurance companies had a tobacco surcharge. If you're smoking tobacco, you got to pay a little more. And that's intended to promote cessation of smoking tobacco. But studies have shown that it does not do that. In fact, it leads to more uninsured individuals. And plans that, because plans, insurance plans that cover tobacco cessation free of charge are popular. And it keeps people out of not having coverage and unable to access this important benefit. And so eliminating the surcharge is projected to reduce the number of uninsured Virginians by about 14,000 people. So the fact the highest uninsured rates are in some of the places where they have the highest rates of tobacco use. So eliminating the surcharge encourages people to get free of charge tobacco cessation programs. And Jeff Lenardi is here to explain it even further. Here you go, come. This amendment?
Okay.
Okay. My impression is if, with this amendment, the governor's okay with it. Jeff? Yeah.
Thank you, Mr. Chairman. Senator Edwards, the amendment that Senator Edwards is requesting at the end of the bill, insert 2 enactment clauses, enactment 3, that the State Corporation Commission shall prepare and deliver an annual report summarizing the reductions in premiums related to the elimination of the tobacco surcharge and the percentage of new enrollees in localities with above average rates of tobacco use to the governor and the chairs of the House Committee on Commerce and Energy and the Senate Committee on Commerce and Labor by January 1st of each year. 4, that the provisions of this act shall expire on January 1, 2026.
Unless reenacted. Yeah.
To adopt the amendment. All right. You heard a motion to adopt the amendment. Is there a second? Second. Motion is second. All those in favor of adopting the amendment, say aye.
Aye.
Opposed? It's adopted.
Jeff Lenardi is here to.
Thank you, Mr. Chairman. Jeff Lenardi, staff to the Joint Commission on Healthcare. Senator Edwards explained the basics of this, and as he said, you all passed this measure last year. Just to articulate sort of why the analysis indicates that this will bring more people into the market and thereby reduce premiums. So the tobacco surcharge is tacked on after any federal subsidy. So as you all know, the vast majority of those in Virginia and nationally in the individual market are heavily subsidized by the federal government for their premiums. So to put some hypothetical numbers to it, if I'm shopping for a sticker price $400 a month insurance plan, and based on my 200% of federal poverty level income, the federal government's going to subsidize that, so I only pay $50 a month. But if I'm a tobacco user and the insurance carrier is charging the full 50%, the premium I'm now responsible for is $250. And so what that acts as is a deterrent. So if I'm a tobacco user with high health care needs, maybe that $250 is worth it to me because I have to go to the doctor a lot. I may have ongoing medications. But if I'm a younger, healthier tobacco user, I may not see that $250 a month premium as necessary. And so what the research found is that it's acts as a deterrent, particularly those who are younger and healthier, don't have higher healthcare needs. And so by removing it, the goal is to bring more of those individuals into the market, thereby lowering premiums. So happy to answer any additional questions.
Mr. Chair, members of the committee, my name is Kelly Fitzgerald. I'm representing the American Cancer Society Cancer Action Network. We thank the patron for bringing this bill forward. We're very supportive of it. As you've heard, it is not having the intended consequence that it was meant to have. And the best thing for a person is to have access to a health insurance policy, especially if they're trying to quit smoking, to have access to those smoking cessation products. So we would love to remove this barrier to health insurance. And again, we're very supportive. Thank you.
Mr. Chairman, Clark Barron with the Medical Society of Virginia, and we support the bill.
Afternoon, Sarah Cariano, Virginia Poverty Law Center. We support. Thank you.
Mr. Chair, members of the committee, Freddie Mejia with the Commonwealth Institute, and we support the bill. Thank you.
Those on Zoom who would like to provide testimony, please raise your hand. There are no speakers, Mr. Chairman.
Motion and a second. Excuse me. Report Senate Bill 1011 as amended. All those in favor, vote aye. Opposed, nay.
Ayes 15, no 0.
Senator Edwards, you got 1018.
That bill should go by for the week. It has, they're working with the railroads. Okay.
Senate Bill 1029, Senator Scanlon.
Afternoon, Mr. Chairman. Mr. Chairman, with regard to Senate Bill 1029, and that's the fiber optic cable bill over railroads, I've asked the stakeholders to get together and meet in my office. So if you would pass that by for the week, by for the day, that'd be great. See if we can work something out. And I have two other bills if you want to take those up. Thank you.
Which ones?
1120 and 1123. You can kill them in a block or take them up and kill them individually. Or send them all to finance like I'm sure Senator Howell wants. Yes, sir, Mr. Chair, members of the committee. If we noticed during the time where we had so many unemployment claims through the VEC, and there was, of course, money that was provided for during the pandemic, my understanding is that $14 billion or more was given out in unemployment. And ladies and gentlemen, $1 billion of that, $1 billion with a B, was obtained under false pretenses using false identities, identity theft. Over $100 million was fraudulently obtained by people that used their own names but weren't entitled to it. And yes, sir, just in Virginia. And so what this tries to do is it tries to authorize the VEC and especially the commissioner the authority to be able to subpoena records related to unemployment insurance fraud claims and cases. Right now, the VEC and the commission do not have that kind of power, and they need that kind of power really to dive in and go get those bank records and determine for themselves, especially if we're talking about identity theft, get to the root party that used someone else's identity to fraudulently obtain VEC benefits. Mr. Chairman, members of the committee, this is something that we should all be, I guess, locking arms together and making sure that we stop waste, fraud, and abuse, especially through the Virginia Employment Commission, because, number one, it's an important commission that makes sure that we're handling as a safety net those that lose their jobs, especially if they lost their job in the pandemic, and helps them bridge the gap so they're not destitute. But at the same time, the abuse of trust that people out there, maybe they're in the Commonwealth of Virginia, maybe they're in a foreign country, that people are utilizing to take taxpayer money away from people that truly could have used that money to sustain themselves through the pandemic or whenever they have
a situation where they're unemployed is just unacceptable and should never be acceptable in the Commonwealth of Virginia. So this bill basically authorizes the VEC commissioner to assign agency staff the ability to subpoena records and statements related to unemployment insurance fraud, and it empowers our fraud investigators to gather evidence in connection with that investigation and the adjudication of disputed claims, and assists in quicker prosecutions. Right now, I think, Mr. Chairman, you would agree that we are bogged down in trying to get through this tangled mess of prosecutions, investigations, and this would streamline and give the VEC that ability to cut to the core, get the documents they need to have, be able to determine if a fraud has occurred, and from there, to be able to prosecute that fraud and get that taxpayer money back and put it back where it should belong. And that's the bill, Mr. Chairman.
Mr. Chairman. Bill.
Sir.
I don't know whether you remember, but I don't know, 4, 5, 6 years ago, the Division of Child Support Enforcement was utilizing non-lawyers to prepare pleadings and subpoenas and orders, and that was, I think, determined to be unauthorized practice of law. I suppose we could authorize it by code, but is that a good idea?
Mr. Chairman, I would answer the gentleman by saying I can understand usually what we're talking about in a legal process in civil matters or even child support enforcement, I think is a little bit different, and even though it is just as devastating when a parent is not providing the financial support ordered by court. But what we have here is such a large problem, and at least, you know, we're looking probably at the next 2 years of this really is a need. But our local prosecutors do not have the capacity right now to do this in concert with the VEC, and especially depending on where the fraud may have occurred, and that's the second bill that I have there. If we're concerned about perhaps making sure that there is some attorney oversight, then we can also, you know, we could look at perhaps having a review by the Attorney General's office, perhaps as a layer of review with regard to those concerns that you may have that only attorneys should issue subpoenas.
Mr. Chairman.
But this is like a police power, and police powers issue subpoenas as well.
Mr. Chairman, it sounds an awful lot like the same argument that DC Department of Child Support Enforcement made a few years ago. They were short manpower, and in any event, thank you.
Mr. Chairman. Mr. Chairman, I joke all the time about lawyers. I joke all the time about lawyers having book sense but not brain sense, but I definitely don't want to have me, a person like me, to do this without a lawyer who knows what's going on. Go down, hey. I'm trying to talk. But I definitely, to me, I'm concerned about having a non-lawyer who probably knows something to do something that a lawyer knows about, especially within their purview. And I'd be scared to death to have a person like me who I think I'm the smartest person in the world, but I'm not a lawyer either. I want to make sure that there's a lawyer, someone who knows the business, who knows what's going on, than just have someone like me that's got plain old common sense. I'd be scared to death to do that.
Mr. Chairman, first I would address Senator Sproul by saying if Senator Lucas was not on this panel, I would say you are the smartest man in the world. But now I won't. But if you allow the VEC to explain, I think, what we're trying to do, there are limitations and parameters we can put around this. But if there is no way to fight this criminal behavior without empowering the VEC with some sort of tool to be able to get those financial records to determine where the money went and who it went to.
Mr. Chairman, members of the committee, I'm Carrie Roth. I'm the Commissioner of the Virginia Employment Commission, and this is actually something that was brought up to us in working with the Virginia Attorney General's office. We have 2 prosecutors. Sure. This is actually an issue that was brought up to us in working with the Virginia Attorney General's office. We have 2 prosecutors that we pay for, and to be able to have these bank records in particular would help streamline that process for them as we build cases to criminalize this. I just also, to speak to the senator's issues, we do have this appeal, the ability for subpoenas under appeal. This is something that we already are authorized to do. In addition, related to taxes, The alternative is actually to issue warrants, which is also already allowed for us under the statute. So having a subpoena for taxes is a lot more of a friendlier way to address those issues than what we currently have to do, which is issue a warrant, and then the agency represents those. So really, we're trying to make sure that we can get the information in the most expeditious way to be able to prosecute these crimes, and that we do work with the Attorney General's office on preparing these.
Yes.
Do you currently have the authority that any representative of the VEC can take depositions?
Mr. Chairman, members of the committee, that those would have to be authorized by the commissioner. So it's not just anybody who would be able to do this. It would have to be somebody authorized.
Mr. Chairman, as I read the statute that is proposed in the pretty simple language, it says authorize any representative to have the power to administer oaths, take depositions, and certify to official acts. It seems to me that you may be moving in the direction of having the ability, and intentional or unintentional, to delegate the ability to take depositions down to some very low-level administrative personnel.
Mr. Chairman, members of the committee, if there's some additional language that you might have that might feel more comfortable with, we would be open to that. But the reality is we need to make sure that we can, get this information from the bank records, in particular for frauds. We can get this to our prosecutors at the state and federal level in a more expeditious fashion to be able to recover these funds that are put in there by our Virginia employers.
Thank you, Mr. Chairman. Would there be training that would accompany this authority being granted to these individuals?
Mr. Chairman, members of the committee, Senator Marsden, this isn't something that we take lightly. This is a very, sorry, I'm not tall enough. This is not something that, we take lightly. And again, like I said, the right now for the tax side, we do have some authority around this, that is, around warrants. So this is something that is very serious. We do have training that's around this. We can increase training. Is very important to me that we are continually doing training around this, but we also work directly with the Virginia Attorney General's office for this, for the bank records.
Mr. Chairman, just a comment. There's something similar, juvenile probation officers who are non-attorneys being able to issue arrest warrants, able to take charges, do these things because they're adequately trained to do that. Magistrates, the same way. I don't know if that's analogous to this situation, but it seems that it is, and as long as there are certain limitations to what they can do, is that training can overcome the lack of a law degree or that, we need to run an efficient government, and we can't oversubscribe to having very expensive services added to the process and to allow people to do their jobs as long as they're adequately trained.
Right.
Mr. Chairman, I have a question.
Mr. Chairman, I'm wondering if this can't go by for the week, and here's why. Clearly, this is a problem. Those of us that are employers got saved by the general fund, and that's the only reason why we're not paying extraordinary rates. And we messed this up, and I know your department is trying to figure it out, and heaven knows those people that worked in this position the last couple of years had the hardest job in state government. So I think we need to figure out how to do it. I think Senator Obenchain and Senator Norman bring up legitimate issues, and I think we can get past that. But kind of legislating on the fly for something I hope we all agree we need to pass is probably not the best move. Mr. Chairman, I wonder if the committee would agree to a substitute motion if the bill go by for the day.
Yeah. Mr. Chairman, I just have a quick, simple question.
Mr. Chairman, I would join in this, and another concern that I have is if we provide this in a statutory provision, it basically is empowering an administrative individual to undertake the performances of an attorney. Use the term prosecutor. A prosecutor is not a synonym for any representative. And my concern is if we put something like this in the code, we're going to be confronted with other agencies wanting to do the same thing, and I just don't think it's healthy. And I don't make the analogy to a probation officer, and I've never been one, but, unlike Stanley, I've lost a criminal case or two, and my experience has been that when a defendant violates some of the terms and conditions, at least in my world, the probation officer doesn't issue a warrant. They send a letter to the court requesting them to issue a capias to have the individual picked up. But that aside, I would encourage you to look.
Mr. Chairman, I would just tell the Senator Norman that in some situations the capias is used. In other cases, they go straight to a detention order, which is allowed to be.
All right, is there a motion?
Yeah, I just had a simple question. I don't disagree. How much money are we talking about?
Is there a motion and a second?
Huh?
1.1 billion. I have Senate Bill 1120 go by, and hopefully they can reorder amendment that would make, that would satisfy all the various parties concerned, which essentially is you all and us. All those in favor of it going by for the week, say aye. Aye. Opposed? All right, it's by for the week. Senator Stanley, you have 1123.
I do. Mr. Chairman, members of the committee, this bill is amends 60.2119, which allows then the prosecution of unemployment insurance fraud claims anywhere in the Commonwealth. Right now, it was in the city of Richmond, and only solitary venue in the city of Richmond. Back in the day, that's where VEC was. VEC is now located, ladies and gentlemen of this committee, in Henrico. But there's a reason for wanting or giving a venue provision such as this, because it would allow the agency or prosecutors and Commonwealth's attorney working together to prosecute actually a defendant at the location where the fraud in fact occurred. So this expands venue in terms of allowing for local prosecution. That's going to expedite these processes. It creates more efficiency for the agency, and that's, I don't know anybody would have a problem with that, but I think we ought to be able to spread this around, not focus it on one city or one county's municipal building or courts of justice, because these number of cases which are anticipated to occur at least over the next 2 years are numerous, and we know as a lawyer right now there are a lot of court systems that are backed up from the pandemic. They're backed up with the increase in jury trials in criminal cases. And so this gives that kind of flexibility in terms of venue for the prosecution to occur. And that's the bill, Mr. Chairman.
Any questions of the paper? Move the report. Second. Motion and a second to report Senate Bill 1123. All, first of all, let me ask, is there anybody in opposition to the bill? Okay, got a motion before you to report Senate Bill 1123. All those in favor vote aye. Those opposed, nay.
Ayes 15, no 0.
Thank you, Mr. Chairman, members of the committee. I appreciate it greatly, and I'll see you next week.
Jack, you had prescription drug affordability board.
Yes, sir.
Senate Bill 957.
Thank you, Mr. Chair, members of this committee. This is Senate Bill 957, which is the Prescription Drug Affordability Board. This is a bill I brought last year. It was a little bit ahead of its time, but I think it is actually more timely this year. Let me give you a little bit of context. Last year, the United States Congress passed the Manchin-Schumer bill, which, among other things, allowed the federal government for the first time to bargain with pharmaceutical companies in order to establish what's called a UPL, an upper price limit for certain drugs that are highly in demand and highly expensive, and based on that UPL to set the price for what would be the Medicare market, which, of course, is a federal obligation. We will start seeing those UPLs being decided by the federal government, and that information will then become available to us, which is important in two aspects. One, of course, for Medicaid, where we go out and purchase the drugs for our constituents, and that, of course, is a burden on the state taxpayer. And then secondly, in the private market, where we have constituents that are buying drugs on the private market, and of course, they're very expensive, and drugs can be, some drugs are highly in demand. And so what this is a Prescription Drug Affordability Board, which gives them the authority to set the price on certain high-demand, high-priced drugs. It's a bill that's been passed in Maryland, Colorado, and I believe at least 2 other states. The bill that was passed in Maryland it passed without a veto by Governor Hogan, but has not yet been funded. So it's still kind of an idea that's taking shape. But the key part is that now that we have the federal law regarding the UPLs, for the first time, we're going to have the information about what a fair market price is for these very expensive drugs, which are on the market and which are being paid for by our constituents and which are being paid for by our taxpayers. And with this information, frankly, we have a unique opportunity to go out and protect our constituents, protect our taxpayers, and protect consumers. So that's a sort of a 3-minute preamble. I've got reps from here from AARP and from other folks that I know are anxious to speak on this bill, and I would like to defer my time to them. Okay, where are my supporters? I was scared there for a second.
Mr. Chairman, members of the committee, Jared Calfee with AARP Virginia. On behalf of our nearly 1 million members across the Commonwealth, we very strongly support this legislation, and we thank the Senator for bringing it. We are in a time of historic inflation, and even with the 8.6% inflation that we've seen, the price increase of prescription drugs has far outpaced that. Between 2021 and 2022, we saw the price of prescription drugs go up around 31.5%. These kinds of price increases are unjustifiable and they're not sustainable, and they're causing harm to folks here in Virginia. A prescription drug affordability board would help us address this problem by keeping down some of these most expensive drugs that are treating life-threatening illnesses like cancer and diabetes. It would save the state and taxpayers money by reducing expenses in our Medicaid program and the state health plan. So I hope it will be the will of the committee to support this legislation. Thank you.
Mr. Chair, members of the committee, Karis Mitchell, on behalf of the Virginia Catholic Conference, we also support this bill. Thank you.
Thank you, Mr. Chairman and members of the committee. My name is Rena Hicks. I am the Executive Director of Freedom Virginia. We are a nonprofit organization that advocates for economic security policies so that each and every one of us can reach financial freedom and increase our opportunities. I'm here in support of Senator Peterson's bill to establish a PDAB. I could read off really compelling stats and facts, like 1 out of every 4 Virginians who depend on prescription medicines chooses not to take it solely because they cannot afford them, or that 82% of Virginia voters, including the wide majorities of Democrats, Republicans, and independents, support the creation of PDAB. But ultimately, it's important that we recognize there are real people behind these numbers. They live in Virginia, and they're your constituents. Your office has received a digital copy of this, which is a compilation of stories around high prescription drug costs that we've collected for nearly a year. I'll read one to you now to preview, and this is from Nancy in Chesapeake. I have asthma and I need an inhaler. The copay for my inhaler is $90 a month. The inhaler itself costs $489. I'm retired, I'm on Social Security, and I cannot afford these high costs, even though I need this inhaler to keep me alive. I am 73 years old, and I have been forced to stretch out my inhaler in order to spend less money. I know that this is dangerous, but I do not have a choice because I cannot afford $90 a month. Unjust price gouging by pharmaceutical companies is one of the leading factors in cost of living increases, and as legislators, you have the power to do something about that right here and right now. Please vote yes to SB 957. And thank you, Senator Peterson.
Mr. Chair, members of the committee, Patrice Lewis, I'm here with the Impact Project. Also have Ryan O'Toole here who has, if you have any technical questions, he will be able to answer those. We do support and reiterate everything AARP Freedom Virginia said. Thank you.
Good afternoon, Mr. Chairman and the honorable committee members. My name is Kanan Srinivasan. I'm a finance professional with a deep involvement in healthcare. I currently serve in the Medicaid Board of Virginia as its vice chair and at GW Heart and Vascular and Loudon Free Clinic. I'm here in my personal capacity as a private citizen, and I'm not representing any of the boards I serve. Healthcare costs are rising faster than CPI. Prescription cost is a significant portion of the healthcare cost. I fully support forming PDAP in Virginia, as it will provide a comprehensive view and a fair transparency and a fair view of review of cost. This will be a significant and a good step in the right direction. And I fully support this, and I really appreciate you listening to us. Thank you.
Good afternoon, Mr. Chair. Jeremy Bennett with the Virginia Association of Counties, VACO. For the reasons stated, we support the legislation.
For those on Zoom,
I have a question. Chap, I understand for the first time, based on what the feds are doing, that we're going to have some realistic perspective on the cost of these high-priced medications. My question is that merely persuasive to the state agency you're trying to create, or can they have the discretion to recommend and try to control an even lower price than might be disclosed by the feds?
Well, thank you, Your Honor. If you direct your attention to lines 247, or Senator Norman, 247 to 241, it says the board may adopt the Medicare maximum price. So they have that discretion. You know, if there's a reason that there needs to be a stronger return on equity, or there's a little bit longer of a sort of a stranded cost return, then they would have the discretion to go longer. And the short answer is they're not bound to it.
Is there those out there in opposition to the bill?
So I've obviously spoken with Chap about this bill. Mr. Chairman, members of the committee, this is a very well-intentioned bill, but with a very expensive and terrible policy behind it. As Chap discussed, the bill does set up a taxpayer-funded commission. I'm sorry. Us tall people have to lean in, I guess. This will aims to set up a taxpayer-funded commission in the state that would look, assess, and set an upper payment limit on what the state would reimburse for. We have seen this bill passed in Maryland. I actually worked this bill quite intimately, and I can tell you that it was passed in 2019. It cost the state of Maryland and its taxpayers to date $2.5 million and has yet to save a patient 1 cent at the pharmacy counter. Senator Peterson's bill from last year had a fiscal note of $670,000 in the initial year and $644,000 in the second year. As Senator Peterson talked about, Congress did pass and President Biden did sign the IRA, the Inflation Reduction Act. In that bill contains mandates on manufacturers to negotiate pricing. And so what I would ask this committee respectfully is to pause and let the federal government do its work. So many times we here in the Commonwealth have to act on our own because Congress is delayed in their response to things that impact us, but they actually have taken action. The first report from the IRA is due in 2023, so we're not waiting a long period of time for them to take action. They have consecutive reports coming out on the top 10 drugs that actually expands to 25 drugs in 24, 25, and 26. So you are looking at something that's going to be done by the federal government as well. So my advice would be that maybe to take a pause and let the federal government do their work. Happy to take any questions. One last point I'll make is that the Joint Commission on Healthcare did review this policy and look at this issue and decided to take a pause and let the IRA take its and make its impact on Virginia before they acted. And so that was decided in early fall by the Joint Commission. Happy to take any questions. I also have my policy expert here, Sharice Johnson, who can answer a lot more about how the IRA might and can and will impact Virginia and drug pricing. Again, happy to take any questions.
Mr. Chairman? Mr. Chairman?
Senator Bell.
Could you please state your name and who you represent?
I'm sorry, Nicole Pallia-Wood on behalf of the Pharmaceutical Research and Manufacturers of America.
Okay. All right. Scott, you're up.
Thank you, Mr. Chairman, members of the committee. Scott Johnson, I represent the Virginia Biotechnology Association. The association has 240 members in the Commonwealth. These are the companies that are developing the new drugs and doing clinical trials and working with that. I certainly respect my good friend Senator Peterson and appreciate his understanding, but I want to bring a different perspective to you. You're looking at it from the cost of drugs, and I'm not saying you shouldn't, but there's a different component to consider. Virginia competes on a daily basis when it comes to pharmaceutical research and development and clinical trials with our friends in Boston, Massachusetts. And when people are looking to invest money to develop drugs, they're looking at the environment of where it's best to do that. Virginia's got a good environment. We do not want to put ourselves on a competitive disadvantage. Realize, too, we learn from mistakes of other states. Maryland has made a mistake. They've spent a lot of money. They've had this on the books for some years, and they have effectuated 0 drugs. We can do better. I encourage you to not advance this. I appreciate your time on behalf of our member companies. Thank you.
All right, anyone else desiring to offer up an opinion, okay?
There are several speakers on Zoom, Mr. Chairman. There are several speakers on Zoom, Mr. Chairman.
Two on Zoom.
Mr. Chairman, I guess before you take the Zoom calls, chat board to staff, is there a fiscal on this? Normally, these kind of bills get a fiscal, and I can't online find the fiscal.
I filed a budget amendment just for the compensation of the board itself. There will be a savings, obviously, in Medicaid once we enact it, but, you know, I don't have any precise numbers.
Tom?
Mr. Chairman, Senator Newman, a fiscal impact statement has not been posted, but I would note that Mr. Chairman received a letter from Senate Finance and Appropriations on this bill asking.
They want it, right?
Okay. Thank you, Mr. Chairman.
All right, I need a motion one way or another. Second. All right, there's been a motion and a second to report. And refer to Senate Finance, Senate Bill 957. All those in favor of reporting and referring to Senate Finance vote aye. Those who oppose vote no.
Survey says.
George.
Barker.
Ayes 11, noes 4.
All right, the bill is reported and referred to Senate Finance.
Thank you, Mr. Chair.
Okay. All right. Senator Pike. You have Senate Bill 1037.
Yes, sir.
1038 and 1039.
Yes, sir. Senate Bill 1037, Mr. Chairman, should look familiar to you. This bill passed the Senate last year. This is requires the notice of appeal rights at a denial letter. So when an employee going through the workman's comp claim receives a denial letter, they simply attach the statement associated within this bill along with that letter. This is a recommendation from JLARC from, I believe, 2020, and that is the bill, Mr. Chairman.
All right, any questions in the paper now? All right, anyone here in support of the bill?
Mr. Chair, members of the committee, on behalf of the Virginia Professional Firefighters, 10,000 members, we support the bill. As Senator mentioned, this is a recommendation from the 2019 Comprehensive Study on Workers' Compensation that JLARC completed, so we hope that you'll advance the bill. Thank you.
Mr. Chairman, Devin Cabot on behalf of the Virginia Fire Chiefs Association, they support the bill.
All right.
Mr. Chairman.
Senator Newman.
Senator Pike, is this a letter that is already going out and you are prescribing the language, or is this new communication?
Mr. Chairman, I'd respond to the senator that when you receive your first workman's comp claim, you get a letter basically with similar language on appeals process. The problem is from your initial packet to when you get a denial letter. The point of inflection is when we want to make sure that those employees that have a denial letter, they know their rights, but often it's time 6, 8 months after the initial claim, and so they may not have the paperwork, they might not have all the information. So much like we've seen a confusion on VEC cases on who to go, the same is true here. We're simply giving the additional information at that denial point so they know their rights. And so this is helping them to connect the dots, Mr. Chairman.
Mr. Chairman, is this the commission that's sending the letter or the employer? Who's sending this letter?
It depends. Usually, it could be the employer in self-insurer cases. It could be those who are providing your workman's comp insurance. So it depends on how the individual company is set up. Some are larger and deal with it themselves. Some are smaller and contract that service out. So it just depends on the individual nature.
Okay. Any other questions? All right, the bill is, yes, sir, it's all right.
You might have some comments as well. Opposition or concern?
Again, Jeff Smith.
Mild concern.
Mild concern. With all due respect to the patron, we spoke with him about our concerns with the bill. To Senator Newman's point, our employers, as well as providers that pay a tax to the Workers' Compensation Commission, and there's a packet that's sent to injured workers kind of detailing what is done. Our opposition to the bill is simply that it's while we pay the tax in order to provide the injured worker the notice, and so we feel like this is duplicative, and that's our opposition. Hey, thanks.
All right. Bill, before
Move to report. Move to
What's that?
report, and there was a second from Senator Mason.
Is there a motion?
Yeah, move to report, and Senator Mason seconded it.
Okay, I can hear that. All right. There's been a motion to report Senate Bill 1037. All those in favor, say aye or vote aye. Those opposed, nay.
Ayes 13, noes 2.
13-2, bill approved.
Thank you, Mr. Chairman. The next bill is Senate Bill 1038. And Mr. Chairman, members of the committee, this is adding to our Cancer Presumption Act for bomb and arson investigators, as well as those dealing with hazardous materials. You'll see in the existing code today that we actually have defined Department of Emergency Management hazardous materials officers. And between the other categories, frankly, we thought it was kind of covered, but it's not. For instance, state police officers that are dealing with meth labs or hazardous incidents. You see, we also have the state troopers dealing with motor carrier safety. And so we actually have a lot of those categories, but we actually don't have the hazmat state police that are dealing with meth labs. And so we thought it was covered, but it's not. And so we were clarifying this language to make sure it's roughly 100 employees are actually covered under this Cancer Presumption Act. This is sort of an important loophole that we want to close to make sure that those who are dealing with, between different arsons, chemicals involved, and the investigations and materials that they have to handle, that they are covered, in fact, under the presumption, as they're dealing with the same category of materials that is already under our existing code.
All right. Questions of the paper? All right. Those speaking in favor of the bill? Senator Northam?
Thank you, Mr. Chairman, and thank you, Senator McPike. I won't mess it up now. I could do that at one time, but I don't. But I appreciate him bringing this forward. This came to our attention that it was presumed that all of our arson investigators, bomb techs, meth lab cleanup troopers that go out and clean up meth labs were covered. But after looking into the code, it was determined that these are not firemen. They're not firemen. They're not hazmat team members, and the evidence collectors that analyze and collect the evidence and we asked Senator McPike to include them in the code. There shouldn't be a financial impact because it's always been assumed that they were covered. So when we look back at how many of this that did not cover under this code, there was about 125, 45 or so arson investigators that are not firemen, about 60 meth lab agents and troopers that clean up meth labs, and there's about 20 analysts that handle all the material. So we'd appreciate you looking favorable on the bill.
All right, is there any opposition to the bill? Okay, the bill is before us. What? This is important for the finance. Second. There's a motion, is there a second? Second. Motion and a second to report and refer to Senate Bill 1038 to Senate Finance. All those in favor vote aye. Opposed, nay.
Ayes 15, no zero.
Thank you, Mr. Chairman, and I believe Senate Bill 1039 has been rolled into Senator Bell's and passed by for the day, so appreciate your time.
Right, okay. All right, Senator Evans? Senate Bill 1086.
Senate Bill 1086 should look familiar as it's from legislation that Senator Hashmi and I brought last year that passed this committee unanimously that had two parts to the bill dealing with living organ donors. Last year, we passed legislation to forbid insurance discrimination against living organ donors, and this committee and the Senate passed unanimously legislation that would also allow for unpaid leave for people who donate a living organ like a kidney or bone marrow. And it's similar to federal legislation from Senator Tom Cotton and Kristen Gillibrand. What happened last year in some confusion, the House did not take up the portion that dealt with unpaid leave. So this is only for larger employers with, I believe it's 15 or more employees, that an employee could take up to 60 days of unpaid leave after they'd worked there for a year or more. And that's the bill that we brought to you last year that you had passed unanimously. I don't know if there are witnesses online or not.
Mr. Chairman.
Senator
Sir Evan, thank you for bringing this. The federal legislation, does that deal with employers with as few as 15 employees?
I don't know what the federal language is, but there are some other states that have passed similar bills. This affects a relatively small number of people. In 2021, for example, there were 684 total kidney transplants performed in Virginia, but only 170 of those people received transplants from living donors, and 34 living liver transports. So we're talking about, at least in 2021, about 200 Virginia organ donors.
And, Mr. Chairman, further question. Look, I support your rationale. I support employers who are able to make that accommodation. And I understand that there aren't many of these situations, but if I would take issue with your characterization of 15 employees as a large employer. And if I'm an employer with 15 and lightning strikes, I'd be delighted if I am able to accommodate my employee, but I'm worried about some employers who just may not be able to, especially if they're 15, if they have 15 employees and now we're down to 14, not able to accommodate that. And I don't know whether you or the members of the committee would be open to increasing that threshold.
I'd be open to it, but I don't know what the magic number is. We've had 28 states that have passed some provisions of the Living Donor Protection Act in some form, including Maryland and Kentucky, but I can't tell you how many. We use their model legislation in establishing the number of employees, but I don't know if they all mirror it exactly. But I'd be open to other numbers, but it's, it's not convenient to have an employee take leave unpaid or not.
It may be more than just not convenient. I mean, it may be devastating to a small business. I don't know. I might suggest 50, but I don't know.
Mr. Chairman,
Senator Newman.
what's the ERISA number? We use ERISA number for a lot of things. Tom, is ERISA number 50, or what's the ERISA number?
If you give me a second, I'll look it up, Mr. Chairman, Senator Newman.
Mr. Chairman, question while he's looking that up, if I can. About how, you have any idea how many of these would happen in an average year?
Well, like I said, there were about 200 combined kidney and liver in Virginia in 2021, but those are not necessarily, some of those people may have had paid leave that they were able to take, where this is only for unpaid leave and people who have no other recourse to save a life. There are about 108,000 people on waiting lists for life-saving transplants across the country, and 17 die every day waiting for an organ. And then there are transplants for people who expire and donate their organs. That's a separate category.
Mr. Chairman, Senator Newman, I may need to correct myself, but I'm seeing 100 right now.
Mr. Chairman, I think it's 50, and I think it always has been 50 on ERISA. Senator Abbott, as you know, I don't support these very much, but I think this one makes sense with the organ donation. I don't know what you think about 50, but I would support it.
I think we could go ahead with 50.
I'd move that we change on line 22, 15 to 50.
Second. All right, there's a motion to adopt the amendment changing to 50. All those in favor say aye. Aye. All right, amendment's adopted. Move to report as amended. And now, the motion to report.
Second.
And a second to report as amended. All those in favor of reporting Senate Bill 1086, say aye. Aye. Or vote aye. Those opposed, vote nay.
Ayes 15, no 0.
I do. It's Senate Bill 1088, which deals with expanding PTSD coverage to 9/11 dispatchers. This legislation would go into effect only after a qualifying event, which could be an event resulting in serious bodily injury or death to any person or persons involving a minor who's been injured, killed, abused, or exploited, or an immediate threat to life of the claimant or another individual, or mass casualties. We know that 9/11 dispatchers answer calls for help that initiate the response to every emergency in Virginia and deliver often life-saving instructions to the 9/11 caller. They're on an open line and listen to emergency events as they unfold ahead of responding units, console and comfort callers, and direct callers who are seeking a haven while awaiting responding units. And at times, the public safety communicator can be the last voice the caller will ever hear. While they're not physically on the scene, they're with the caller and responding units every step of the way, and can certainly have the symptoms and the results of PTSD. What the bill does is it allows them to qualify, and there's some limitations For example, it has to be within 4 years from the date of the qualifying event, and it's limited to 52 weeks of temporary or total incapacity benefits. And I believe there's a witness.
All right, first, is there any questions on the paper? All right, first, witness, hold on.
Thank you, Mr. Chairman, members of the committee. James Turpin, representing APCO and NENA and the E911 dispatchers, and we support this legislation and believe it's a step in the right direction. Thank you.
Good afternoon, Mr. Chairman. I'm John Jones, representing the Virginia Sheriff's Association, and we are in favor of this bill. These dispatchers are a critical link between the public and the officers on the scene and being dispatched to those incidents.
The Virginia Fire Chiefs Association supports the bill. Thank you.
Mr. Chairman, committee members, Jennifer Pike, Virginia Professional Firefighters, and we support this bill.
Okay, is there any opposition out there?
Mr. Chairman, members of the committee, Jeff Smith here on behalf of the Virginia Self-Insurers Association and Metis Holdings, who oversees all workers' comp liability claims with VACO's risk pool. We are opposed to this bill with respect to Senator Eben, mainly because of the cost. Adding dispatchers to this classification, in our estimation, would be because they're currently classified as clerical employees, and if they were to be switched over, they'd be classified as law enforcement. However, under clerical, the rate is 9 cents per 100, and if you were to switch them over in coding to make them law enforcement, it would up that to $2.40 per 100, and that's a 2,667% increase in premium costs. And if you look at the physical impact with the DHRM and the Attorney General's office, they would have to hire additional people per 100 claims. But that isn't really the significant impact. The significant impact is at the local level. And at the local level, you're going to have quite a bit more claims, and that's where the cost is going to be passed on. And we anticipate that to be several $million. And so for those reasons, we oppose this. We know there is an enhanced benefits study that's going on at JLARC, and maybe we could include this as part of that, because we do think there should be some additional benefits there. However, maybe not through workers' compensation. Thank you.
Good afternoon again, Mr. Chairman. Jeremy Bennett with Virginia Association of Counties, VACO. Again, not opposed to the intent of the bill, but as Mr. Smith indicated, we do have significant concerns with the potential fiscal impact to local governments, and would certainly encourage the committee, if it was in its will, to refer the matter to JLARC for further study.
All right, no one heard it. Is there a motion?
Second.
All right, motion is to report and refer to finance. All those in favor vote aye, those opposed vote no.
Ayes 12, noes 3.
Thank you.
All right. Senator Ashby, you're up. Senator Hackworth, you're on deck.
Good afternoon, Mr. Chair and members of the committee. This bill is SB 1112, and it seeks to bring contraceptive care within the access of those communities who most need that support, primarily low-income individuals who cannot access effective contraceptive care because of the barriers in terms of large copayments and other concerns that make access to care prohibitive. As we know, contraceptive care is not just about birth control. And in fact, for many, many individuals, it is a critical healthcare need. For many individuals, for instance, who use birth control pills or other medications, this is actually health care that helps to stabilize individuals' hormonal needs. It helps to reduce the pain from menstrual issues on a monthly basis, and it really has an impact on quality of life. We know that individuals who cannot access contraceptive and medical care in this area often face many, many concerns beyond just their medical situation. For many women who are experiencing tremendous pain and concerns during their monthly period, during their monthly menstrual cycle, they actually can't go to work. So it can mean loss of pay, loss of income during those times in the month. Sometimes it can lead to loss of jobs. So having equity in accessing contraceptive care is absolutely essential to ensure that all patients receive the kind of care that they necessarily need. So this legislation eliminates the copay and the co-insurance payment or fee that is sometimes added on to contraceptive care, and sometimes in devices such as IUDs, the upfront costs can be so prohibitive that individuals can't access those particular devices and that treatment at all. So we ask that you consider this legislation, and I believe we have folks who are here to speak to the bill as well.
Okay, questions of the paper? All right. Those out there in support of the bill?
Good afternoon, Mr. Chairman and members of the committee. My name is Tarina Keene. I'm the Executive Director of Repro Rising Virginia. We support SB 1112 because it makes sense to protect access to no copay birth control for Virginians. This bill simply enshrines current federal law into our code. It does not ask health insurers to do anything they are not already doing. Furthermore, Virginians overwhelmingly support this provision. Research shows that 99% of women use some form of birth control spanning their 30-year reproductive lifetime. Having affordable access to the form of contraceptive that works best for each person is critical to being able to plan if, when, how, and with whom to start or grow their family. Nearly 6 in 10 voters ranked healthcare access as one of their top priority issues this past November. And nationally, despite party affiliation and despite religion, the no copay birth control benefit is one of the most popular provisions of the federal healthcare law. Again, this bill takes this popular insurance benefit and enshrines it in Virginia law. Access to contraception is a win-win issue for people who can become pregnant, their families, and for people running for office. Virginians should not be afraid to lose their important healthcare benefit. But the fear is understandable. Birth control bills can cost between $160 to $600 annually, while IUDs and other implants can cost $500 to $1,000 for initial insertion. Also, as a reminder, birth control pills can be used to help alleviate reproductive health care conditions such as endometriosis. And unfortunately, these safe and effective forms of birth control can be cost prohibitive. I will do that, sir. Especially for people of color and gender-expansive people who already have difficulty accessing health care. We want to make this more equitable. So thank you so much. This is good policy. We hope you will support the bill.
Thank you. Hello, my name is Galina Varchena, and I'm the Policy Director for Birth and Color RVA. It is a doula collective that supports Black maternal health, and we support the bill for all of the reasons previously stated.
All right, any opposition?
Good afternoon, Mr. Chairman, members of the committee. Jeff Caruso with the Virginia Catholic Conference. I think you're familiar with our views on this type of legislation from similar legislation that's been proposed in the past. Our main objection being that there are some organizations whose religious beliefs do not allow them to provide coverage for contraceptives, including our two dioceses. And similarly, there are other organizations that have moral objections, such as Hobby Lobby. And in the case of Hobby Lobby, as well as the Little Sisters of the Poor, they took this issue all the way to the U.S. Supreme Court and were successful. So in our view, this raises significant First Amendment issues, as well as issues under the religious liberty provisions of Virginia's Constitution. We would urge you to oppose the bill. Thank you.
Hello, I'm Heidi Dix with the Virginia Association of Health Plans, and as many of you know, there's already several federal requirements around contraceptive access, and we believe this would actually be a change in cost sharing and therefore a state mandate, which have to be considered by the Health Insurance Reform Commission. Thank you.
Mr. Chairman? The lady who on the end, thank you. Mind coming up, please? Yes, ma'am. I want to ask a question. I noticed whenever someone wanted to get a bill passed, and so my question to you is that they always did a word, particular women of color. Is this more than just a black thing, this is for everybody? Because I'm noticing that it bothers me when people get up, I see yourself get up and talk about health care, what you need, so forth. They always do that word in particular women of color. So this more than just color thing or just a black, what is this you're trying to say?
No, absolutely not. It does help everyone, but it does alleviate some. There are contraceptive deserts across the state, across this country, and we want to make sure, because there are people who tend to be lower income, as well as people of color, who tend to fall into those contraceptive deserts.
And there are more people than lower income just in color, right? So white
Absolutely.
people too, right?
Absolutely, absolutely. This would definitely affect everyone, but it does try to equalize and make it more equitable to get this kind of health care.
There are
four.
people.
Oh, there's a couple of people on Zoom. All right. You have approximately 1 minute each. Go ahead.
Denise Harrington, please unmute now and provide your testimony, please.
Thank you very much. Thank you very much, members of the committee. My name is Denise Harrington, and I'm Director of Advocacy for the League of Women Voters of Virginia. The League of Women Voters of Virginia supports SB 1112. People should be able to start a family whenever they have determined the time is right. Thus, having the financial support with unnecessary expenses out of their pockets, such as copays, financial delays, costly or delayed reimbursements, would help families utilize contraception without barriers. This would also empower families to make their own decisions regarding their contraception. If passed, this bill would eliminate financial hardship as a barrier and factor in family planning. And we have over 2,000 plus members in the League of Women Voters of Virginia all across this state. And this is unanimously supported by our members. I urge you to support SB 1112. Thank you very much.
Rachna V, please unmute and provide your testimony, please.
Hello, my name is Rachna Vanjani. I am an OBGYN and abortion provider at Whole Women's Health in Alexandria, Virginia. I was raised in Fairfax, Virginia, and just recently returned. The previous 7 years, I was practicing medicine in California. I'm surprised at the barriers of contraceptive access that I've noticed while practicing in Virginia compared to California. One barrier I notice is that patients who come in for an abortion and desire long-acting reversible contraception are unable to obtain this method of birth control on the same day. Instead, they have to fill out a piece of paper that they sign and I sign. The paper needs to be faxed to their insurance for approval. They then have to wait for a phone call in order to verbally confirm that they want this method of birth control. And then only after they confirm that will the birth control method be shipped to the clinic and us be able to schedule them an appointment to come back weeks later to get their birth control. Many times patients might miss this phone call because it's from an unknown caller and birth control is never shipped to the clinic and they actually never get the contraception that they desire. Another barrier I've noticed is that patients have to come into the clinic to get refills after a year of being on the pill. And one patient in particular couldn't get an appointment on time and ended up being pregnant, came to see me for her abortion. It's important to remove barriers to contraception. It should be affordable and easy to access. The more we continue to work to decrease the barriers to contraception, the more equitable and just our healthcare system will be. Thank you.
Jamie Lockhart, please unmute and provide your testimony now.
Good afternoon, committee members. I'm Jamie Lockhart. I serve as Executive Director of Planned Parenthood Advocates of Virginia, and I would like to join those who are in support of this legislation. Thank you.
One remaining speaker, Vic Nichols.
Yes. Thank you. I would be in support of this if they had exceptions for the religious, the Catholic ones, and also to make absolutely sure that abortifacient like the morning after pill and mifepristone were not on that list. Thank you.
Okay. Bills before us. Second. Motion and a second to report. All right. All those in favor of reporting Senate Bill 1112, vote aye. Those opposed, vote nay.
Ayes 12, noes 3.
Ayes 12, nays 3, the bill's reported.
Thank you, Mr. Chair.
All right, Senator Hackworth, you're up with 1121.
Thank you, Mr. Chairman, members of the committee. Senate Bill 1126 was brought to us by the Department of Labor. And actually, the purpose of the legislation is to allow the Department of Labor to utilize other vendors than the United States Postal Service to send notices such as FedEx, UPS, any service that actually has a specifically delivery confirmation. There's about 3,000 inspections, about 1,000 notices that's sent every year, and some of those are do not get signed. So they was actually, we have people to speak on if you want to know more about it. Basically, it just allows them to be able to use other carriers that has a delivery confirmation with that. That's the bill. There is a physical impact statement that you can pull up that actually saves the state about $3,100 using this method.
Are there questions?
Yeah, Mr. Chairman?
Senator.
Yeah, I just had one question about the type of service that's employed. It says, in a manner that allows for confirmation of delivery is replacing return receipt requested. So does that mean that the recipient has to no longer sign for it? Would they still have to sign for it to confirm that?
Thank you.
Commissioner Pan.
Mr. Chair, committee, my name is Gary Pan. I am the Commissioner for the Department of Labor and Industry. And specifically to that question, yes, we're looking to have signature and date continued. Okay. May I continue? Just for clarification in regards to this bill, currently the code requires that all citations be delivered to employers 6 months, within 6 months of any alleged violation. Otherwise, that citation becomes invalid. We have a number of employers that refuse to accept the certified mail and sign and date. And as a result, we actually go do personal services, meaning that we try to personally deliver the citation. In some instances, we are not able to secure that delivery. We had this past year 31 instances where we had undeliverable certified mail, and we were in 3 instances we're not able to serve personally. So in those 3 instances, because it exceeded the 6 months, those citations became invalid. So the intent here is to follow the current protocol in regards to continue to use certified mail, attempting personal services, and then in the event that we can't secure, then go to commercial services to secure the date and signature.
Thank you. Is it your experience that certified mail, a lot of times, I think is likely to be bad news, whereas getting a delivery at your door, FedEx, is likely to be good news, so the potential for this actually being delivered has gone up?
Our intention is to make sure that the citation is delivered. That's what we're trying to do. So,
and Mr. Chairman, it would be more likely that it would be accepted and signed for if it's at your door rather than you having to go to the post office and get a certified letter. I know you're going to try certified letters first, but this is actually a way of improving your batting average, if you will. And I think it's a good bill.
Yes, it's intended to try to get the issue addressed, secure the delivery of the citation, and move on with the case without having situations where they become invalid. Yes.
All right. Next speaker.
Thank you.
My name's Robert Field. I'm with the Department of Labor and Industry as well. The question was asked earlier, was part of the section that deals with DPOR as part of the legislation. DPOR, Department of Professional Occupational Regulation, the second section of the bill deals with them, and it's separate from what's part of our legislation. So there, whatever, that 54.1 section has different language than ours about, we were always going to require it, and we can't speak to what DPOR's on that.
All right, anyone opposed to the bill? All right, bills before us. Move to report. Second. Motion and a second to report. Senate Bill 1126. All those in favor? Aye.
Ayes 15, no zero.
15-0, bills reported. 1121 was filed today.
After that, yes.
Okay, Rupp, Senator Rupp, you're up.
Thank you, Mr. Chairman. Senate Bill 1134. This bill is titled the Precision Plastic Manufacturing Grant Fund, and it deals with a development in Chesterfield County that will be the home of a manufacturing facility to be used by Lego. VEDP fully vetted the company, and this proposal was reviewed and approved by the MEI Commission. To qualify for this fund, the business must invest at least $1 billion and employ a minimum of 1,781 full-time employees. The grant funds could not be applied for, could only be applied for beginning in 2027 up to 2035. No funds could be drawn from the funds until at least 500 employees are on staff. This is the Lego deal right here. The state will always have a positive cash flow as the project moves forward. Just one other thing I'll mention is that Lego, you know, we dealt with it with our kids in the last 20 years, but the company is actually closer to 75 years old. Joining us today is Carolina with Lego and the Economic Development Partnership. Any questions?
All right. Welcome.
Good afternoon, Mr. Chair. Angie Jenkins with the Virginia Economic Development Partnership. We appreciate the patron carrying this bill and hope the committee will see to report it, and we're here to answer any questions if you have them. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Carolina Juga. I'm here representing the LEGO Group. I'm their Senior Director for Government and Public Affairs. Thank you so much for having us here today.
Okay. Is there any opposition to the bill? There isn't, right? This is a report to refer to Senate Finance. So moved. Second. All right. All those in favor of voting for glad. Those of you who don't remember, there was a movie called Archival. All right. All those in favor of reporting and referring to finance of Senate Bill 1134. This is an MEI approved project. Vote aye. Those opposed, vote nay.
Thank you, Mr. Chairman of the committee.
Ayes 15, no zero.
Rob, Senator Rob, 1182, we're going to just flat out refer that to Senate Finance.
Thank you, appreciate it.
I think we've put that in there before.
Yeah. Mr. Chair, I think you have to do it separately.
Okay. All right. So we need a motion then. Those favor of referring 1182 to the finance, vote aye.
Ayes 15, no zero.
Get me, Mr. Chairman, this is on par with the economic development opportunity you just heard. Actually, the State Corporation Commission is cleaning up a little language, and if you want to be a resident of Virginia and a title insurance settlement person, you got to take a bunch of tests and you got to pass the exam. They're just saying you need to affirm to them that you've done so and are doing away with the civil and criminal penalties, because what they do is just take your license and they're not going to chase anybody. Not a lot of people masquerading as title settlement agents in Virginia. And then there's a section on viatical settlement providers. So if you have a life insurance policy and you have a terminal illness during the period, there is a broker that can find a contract. You can take the contract in advance. This just says if you're a viatical settlement provider that you have to have a fraud plan in place that makes sure people aren't conducting fraud and saying that they have an illness and they do not. And that if the State Corporation Commission asks to see it, you got to show it to them. I know you've been waiting up all day for this one, Mr. Chairman. Thank you.
What's a viatical? Ayes 15, no zero.